Francesco, ready where you are.
Hi, everyone. Thank you for joining this book presentation and discussion. It's really a pleasure to be the chair of this distinguished panel. We are discussing today the book that is out for some time now by Nicolò Alessi about the law of diversity. And this book is the evolution of his PhD thesis that I also had the privilege to supervise a couple of years ago now. Our hair is getting gray in both cases, so it testifies of the fact that the law is evolving and time is passing. We will have then two excellent discussants in alphabetical order, Lidia Bonifati and Kyriaki Topidi, who are very perfectly suited to discuss the achievements of this book. I will keep it extremely short in order to pass the floor to Nicolò for presenting the main tenets of the book. But while I was thinking how to summarize the whole book, hundreds of pages in just one sentence, I would say, once upon a time there was minority protection, right? And then this thing has changed, has evolved. Its hair have become gray, and things have simply, taken a different shape. And this is part of the nature of every element in constitutional law, which evolves. Of course, things never remain the same. There have been many different additions to the concepts due to the multi-level perspective, to the fact that there are an increasing number of subjects that contribute to shape the law of minorities, diversity management, and the fact that there are several elements that maybe now are being put into questions. Like the changing roles of majority and minorities. This is something that sometimes has been neglected for a long time, that you can be a majority and a minority in the same time, depending on the context, and you can carry different legal backpacks in a way with you, being a majority and a minority contextually. So this also requires some adjustment and some conceptual change. The fact that the rule of law was supposed to prevail over the majority rule in order to protect those who are structurally in a minority position. The fact that law has naturally some cultural biases, needs to work with exceptions, etc. And the concept of the law of diversity tries to encapsulate all that. And the fact that there is pluralization of societies, basically, which means many producers of law, many sources, many actors, negotiations among different subjects with different power relations, etc. So all that requires some reconceptualization. And this is the main element of this book. So the book is trying to reassess the changing phenomena that used to be called minority protection in a more modern and more complex, sophisticated, asymmetric, non-permanent, telluric, call it as you wish, context, in order to provide a conceptual framework to explain this phenomenon. Basically, that's the intention, and my personal feeling is that this has succeeded very, very well. But then I will pass the floor to Nicolò for introducing better than I did how this thing has evolved from once upon a time to now. So Nicolò, the floor is yours, and then we will go straight to the discussions. Thank you.
Thank you very much, Francesco, for your introduction. That always so nice to be introduced by you, and I'm very happy to be here presenting my book. And thank you to Giuseppe and Giacomo and Stas and the Institute of Comparative Federalism at Eurac for hosting this book presentation. And thanks also to Kyriaki and Lidia for accepting to comment on this book. We already had many exchanges also on this work, and I'm always happy to discuss with you the achievements of this book. So I prepared a PowerPoint presentation that I'm going to share now. So I think you can see it. Yep, perfect. So a global law of diversity, evolving models and concepts. My book, my monograph, was published at the end of 2024, actually. So it's been some time that I've been presenting it, and I'm very happy to start presenting the main contents of this book, which has this very nice front page, I would say, and was published by Routledge. So what I try to do in this book, I focus on the global trends concerning the accommodation of diversity within, I say, the constitutional tradition, the variegate constitutional tradition, globally speaking. And then I focus on the most innovative developments in this area. And based on this observation, I try to offer, as Francesco said, a renewed theoretical framework that would help us better frame and understand these most recent developments of this law of diversity that is getting more complex and more sophisticated in some areas of the world. And then the last part of the book is an attempt to use the vocabulary and the toolbox of federalism to understand some of these emergent models of the law of diversity. So the plan of today's presentation is mainly focused on the introduction of this concept to the law of diversity. Concerning that, I naturally owe Francesco and Yes Work and also Tove Malloy something, because they were the first people that coined this expression, and then I tried to develop it in this theoretical perspective. So why this concept? Where does it come from? What is it meant to bring to comparative constitutional theory and practice? And then the second part will be focused on federalism and the law of diversity. A little note on methodology, because my book is based not on a classical comparative method comparing selected a number of case studies, but tries to use a global and dynamic approach. So I do not predetermine a set of countries that I focus on, but I start from a classification of legal instruments for the accommodation of diversity, and then I explain and describe examples in model legal systems. Model legal systems are systems that maybe developed this a model in a particular way, or maybe they were the first systems that developed this model, or they are particularly innovative in some ways. Also, I try to have to apply a decolonial comparative law approach. So what I do, especially in the third chapter, is comparing and proposing perspectives from the global south and on an equal standing with global north models. So we'll see that there are some very interesting macro perspectives, so regional, international perspectives on diversity accommodation that I try to put forward as models that can be assessed on an equal standing with global north models. And also, very importantly, focused on hard and soft law regulations in this area, which are very relevant. So, how the law of diversity was developed. What I did actually, based on the observation of the global trends on diversity accommodation, was then to, after this observation, was to assess if the existing mainstream theoretical tools, so minority rights concepts, are appropriate to grasp the ongoing evolution of this field of law. And I attempt to demonstrate that this perspective can be limiting in a way, and that is the reason why I propose an alternative theoretical perspective to favor a more comprehensive understanding and more comprehensive grasping of this area. So the result, one of the main results of this work is innovation in general theory through legal comparison. So, as I said already, I started in the first chapters of this book studying the evolving significance of diversity within the tradition of constitutionalism. So I started from the origins, and I tried to explore how diversity was accommodated in different epochs. So starting from liberal constitutionalism towards liberal democratic constitutionalism. And then we can see an evolving place of diversity, as we will see in the next slides. And then I focus on the most recent and most innovative developments, which are classified in macro and micro perspective, so more regional perspective, or specific models in selected countries. And then there's the theoretical part. So diversity in the constitutional tradition. I will go quickly with the next few slides, but this book is actually really a path. Is trying to describe this path of growing importance of diversity in the tradition of constitutionalism. So in liberal constitutionalism, equality is central. Citizenship and the principle of majorities and the principle of majority are the basis of the constitutional system. So diversity is limitedly recognized. Generally, is a condition to be avoided in view of achieving equality, formal equality generally. And then with the evolution of constitutionalism, with this democratic element, diversity emerges. Diversity is increasingly taken into account, not only at the domestic level, but also internationally. And then after the Second World War, there's not only an extension of rights and a larger implementation of the principle of equality, but also the creation of this specific corpus of law, which is minority and indigenous people's rights law. And it is in this period that also several constitutional models for the accumulation of diversity are set up. So, which are the models for the accommodation of diversity that emerge from the liberal and liberal democratic tradition of constitutionalism? We have treaty mechanisms at the international level, which have a very ancient origin, actually. We have the use of federalism, and then mostly this development of minority and indigenous people's rights law, which has many dimensions, which implies the protection of the right to existence and survival of minorities, equality, and then specifically minority and indigenous people's rights. So this corpus of law related to diversity is specifically linked to some selected ethnic, linguistic, or religious groups recognized by law. So the accommodation of diversity is conflated with the protection of the rights of some specific minorities. So this is, let's say, the state of the art of this area which I tried to describe in the first chapters, and then starting from the third chapter, I focus more on the emergence. Focus at first on the macro perspectives, and then I identified three regions in which there are very interesting perspectives on the accommodation of diversity: South America, Southeast Asia, and Europe. Three different and complementary perspectives of the accommodation of diversity, which everyone in its way complement and integrate and make this field of law evolve. So, for instance, South America, with the model legal systems of Bolivia and Ecuador, we can see the development of a new constitutional semantics in which plurinationalism and interculturalism are the backbones of the constitutional system, and then also the development, at least on paper, and then naturally there are many issues regarding the implementation of these constitutions, but the setup of a system of governance autonomy for indigenous peoples, a system of autonomy that can be activated at different levels, especially at the local level, based on an initiative from the relevant groups. And then we have Southeast Asia with Singapore, with a completely different perspective, which was very interesting to integrate in this analysis because often is kept apart from analysis based on minority rights. And it is actually a perspective that doesn't talk that much about rights, but is more about governance, about different and variegate measures to make four communities coexist together in this state. So we have a very interesting system that implies not only a particular electoral law, but also measures like the organization of the housing system, which are all aiming to make integrate all the communities together. And then also the European continent shows very interesting developments, especially at the international level, with the development of soft law regulations, especially from the Advisory Committee and the High Commissioner on National Minorities, which both have developed a new conception of integration, which is not anymore connected to an idea of assimilation, but an idea that societies are getting more and more diverse, and then we need minority rights and tools to manage not only specific minorities but societal diversity. So there's a larger perspective on the accommodation of diversity. There's not the demise of minority rights, but a use with a different scope, let's say. And then moving on to the micro perspective, starting from chapter 4, what I focused on are innovative models that have been developing in the global north, especially because these models are lacking theoretical recognition. These are less institutionalized models, are flexible models. They do not follow generally the structure of minority rights tools, and they seem to have an inclusive potential. We will see that, and they have been classified in three categories. So we will have governance or non-orthodox forms of autonomy, legal pluralist autonomous arrangements, and self-governance participatory instruments. As you can see, the idea is that all these models can be framed as forms of self-governance, which is something very important then for the last part of this work, in which we use federalism to frame them. So just to give you an idea of what I worked on in my book on the models that I studied we can find in the category of governance forms of autonomy various arrangements, starting from functional non-territorial autonomy, which is a system that is based on private organization that cooperate with the state and provide services in favor of some minorities or some non-majority groups. This is the case with, for instance, the region of the border between Germany and Denmark. At both sides of the border, there are these private associations that, for instance, manage schools or provide many other services, also in areas that are not necessarily connected to cultural affairs. So, for instance, also homes for elderly, and so on. So this is a very interesting model based on private associations that are supported by the state and by the land. And then we have a similar model in Canada that is called institutional completeness and sectorial autonomy. Also there we have public or private-public autonomous arrangements. Again, they, as we can see, they do not correspond to fully fledged autonomous arrangements. So they are not regions, they are not other kinds of subnational entities, but they are forms of autonomy within, for instance, administrative structures, and that is sectorial autonomy, or through associations, again, that provide some services, some important services for the survival of a non-majority group. For instance, very interesting are school boards of public school in which minority representation is guaranteed, or minorities that manage school boards. We speak of French-speaking minorities outside Quebec. These are the main beneficiaries of these models. But also public health boards. There was a very important affair. There was also decided by judicial decision on a hospital in Ontario to have an hospital that speaks French, in which we can speak French. So these are other interesting models. Then we have nested federalisms, which are forms of decentralization, again, of services and of services in the interest of indigenous communities in Canada. They are called nested federalisms because they are further forms of decentralization, but the constitutional structure of the federal state is not changed. And what is also interesting is that these forms of decentralization are based on agreements between generally the province, the federal government, and the indigenous community, but then are managed by private corporations. So private corporations manage lands. They also provide some services for the relevant communities. They also, for instance, they distribute dividends in the interest of the indigenous people. So there's I would say, a more a larger perspective on the protection of diversity and of a specific community, because the perspective is not only focused on cultural affairs, but also on, for instance, economic independence. So that is very, very interesting. And then I also mentioned and studied revitalized forms of subnational autonomy because they, in another way, are divergent from classic models for minority rights protection and the classic models of autonomy. In a way, the classic model of autonomy is underlined by the idea that a minority owns a specific territory. So it's a majority on a territory and then applies the same logic of a majority. In these models, in which where I mentioned, for instance, South Tyrol in a way kind of evolving towards this direction, there's an attempt to revise this perspective and to make autonomy, or also territorial autonomy, more inclusive beyond classic minorities. And then quickly, legal pluralism also was framed as a form of autonomous self-governance, because this is based on a classification that was made by Tove Malloy, is a way to self-manage the minority affairs, in a way, legal pluralism. But actually, naturally, legal pluralism is very well known, but I focused on less known models, especially the non-institutionalized forms that have been emerging, for instance, in the UK, in the United States, and in Romania, for instance. So these are non-institutionalized forms, especially the gypsy tribunals, or forms of legal pluralism, so forms of tribunals or courts that settle controversies based on legislation that is not specifically addressing minorities. So, for instance, in the UK and in the United States, there's this use of legislation on alternative dispute resolution to settle controversies of minorities, applying religious law, and not only related to family law. So again, I tried to focus on these emergent phenomena, which are not institutionalized, but at the same time having a very important legal relevance. And then the last category is democratic innovations, and then also this category is quite known today, but still overshadowed in studied concerning minorities and in general also constitutional studies. But there also there are interesting models, not only, for instance, consultative bodies in which all minorities or minority groups of a state are represented, but also co-management bodies in which specific areas are co-managed by the public authority with some, for instance, indigenous peoples. So moving on to the evaluation of these instruments. As I said before, all these instruments in a way are divergent from the classic structure of minority rights tools, and especially of the traditional structure of autonomy for minorities. So they have a flexible structure and an inclusive potential because they do not need a legal recognition of a specific group to be activated, for instance. So in a way, we escape public regulations to allow groups manage their affairs. They all have autonomous features, and often they are the result of action from bottom up from the relevant communities. So they are really far less institutionalized models, but at the same time yielding some interesting results. And also their structure is interesting because they could be also maybe interesting models to be applied to other forms of diversity emerging or becoming more salient today. So what I try to suggest, and also I'm trying to suggest in my next publications, is that these models could be interesting also for new minority groups, also for new minorities like groups having a migratory background, for instance. But naturally, there's a point about institutionalization. There are some open questions that I try to answer, at least limitedly, in my book about institutionalization. So, are these models viable but temporary? Are we always focusing on is it our final goal to just achieve political autonomy or territorial autonomy for minorities, or more full-fledged minority tools? What I try to say is that I'm not sure, but at the same time, at least I want to question this idea that full self-government should always be the priority for diversity accommodation, because many of these emerging instruments do have a permanent character once created. So they are kept and they become permanent, and then they also can get more institutionalized and more supported by public authorities. And also these models, being flexible and inclusive this way, can also lead to decreasing tensions between majority and non-majority communities. That's the case that was proven on sectorial autonomy, for instance. At the same time, I'm not saying that these models should be the models that we should apply always in all cases, but these are models that are not generally studied and not generally considered as viable options because they are just generally considered as steps towards a final goal to achieve. So I'm trying to relativize this idea. So in some situations they can be interesting. Naturally, in other situations we do need more, let's say, hard regulations and rigid models. So based on this observation, what really struck me was that classic studies on minority rights and indigenous people's rights do not focus on these emergent models. They do start from the institutional perspective, from the legal recognition, and so theoretically speaking, this minority rights lens and the minority discourse is in a way limiting, because it risks making us overlook all these emerging models that could be interesting and also that can relativize diversity accommodation. So the law of diversity is here not to put aside minority rights, but to complement minority rights, to provide a larger framework to describe the wealth of legal instruments that are sensitive to diversity. So the law of diversity, theoretically speaking, is a platform to appreciate the evolution of this area of law, which has non-discrimination, minority rights, indigenous people's rights, but also emerging models. And this way, these models can communicate more. Practitioners can focus on these models, maybe relativizing the normative assumptions, and there are many that still condition our assessment and use of these models. And at the same time, the law of diversity validates these developments that have not been so much focused on. And then the law of diversity, so as I said, is a toolbox for practitioners that I'm trying to propose these and to develop these in further publications. So the idea is to encourage not only scholars, but also practitioners to use this framework to evaluate the options of accommodation that are available, and not only the usual suspects. And also at the same time, the law of diversity can also show how the accommodation of diversity can evolve in time. So starting from rigid regulations towards maybe more flexible accommodation in situations where detention is decreased, for instance. But yeah, it works. Okay. But where does federalism come in? And that is the last part of my book, because yeah, the law of diversity is very useful to grasp, I hope, this evolution. But at the same time, these emergent models for the accommodation of diversity, especially in the global north, are kind of lacking theoretical recognition. And then I was looking for a framework that could help us better understand them, explain them, but also foster their development, because my feeling is that they can be useful for the development of the accommodation of diversity. So the starting point is that all these models, as we said, are forms of autonomous arrangements, and that was the connection, this autonomy, pluralism, the common ground between diversity accommodation and federalism that I found, theoretically speaking, and then I tried to verify if federalism could be useful to understand these other forms of decentralization. Naturally, this implies something that is not very much liked by, let's say, more traditional scholars or traditional literature on federalism. So we have to distance ourselves a bit from what I call federationalism. So this conflation between federalism and the nation state that implies thinking about federalism as just a form of government implying the territorial division of powers, towards thinking about federalism as an analytical tool for understanding the diffusion of power. Because federalism, as Francesco says very well in many publications, is the most ancient repository of tools to manage the diffusion of powers, to manage pluralism. And it's been naturally linked to its institutional manifestation, but that can also be useful to understand less institutionalized forms of diffusion of powers. That's what I tried to demonstrate at the end of my book, and then I tried to provide some hypotheses that naturally will need more work, but some ideas of what could that mean concretely are showed here. So for instance, these forms of autonomy, forms of accommodation of diversity can be seen as loci of federalism that express self-governance where sovereignty is not to be had. This is a quotation from Gherkin that also used federalism to frame many other forms of decentralization, also related to juries, for instance, were considered loci of federalism. So they can be framed as counterpowers also to the central government, so we can understand the dynamics of and the relationships with the central authorities this way. Also, if we frame these models as federal sites of governance, we can maybe better connect them to federal principles to support them. So naturally, subsidiarity is not only a very important principle in the tradition of constitutionalism, but also in the tradition of federalism, and that could be something that could be useful to encourage support for these models. But also in general, this framing would help us frame the relationships between these models and public authorities as relationships between different layers of governance. So what federalism says about that is that negotiation, for instance, is a founding element, as a working instrument for the accommodation of pluralism, institutional pluralism, but also maybe other forms of pluralism. In case of lack of negotiation, we should expect jurisdictional conflict. We should also expect the need for coordination in case of complex and broader areas of management like diversity accommodation. Also, federal theory can give us many tools to promote solutions in case of conflicts between public authorities and these autonomous models for the accommodation of diversity that can be drawn from the theory and practice of intergovernmental relations, for instance. So why not thinking about developing bodies that can be representing different communities to better communicate with public authorities? And many other instruments coming from federalism can be useful to understand, but also in a way regulate these relations to foster improvement for the accommodation of diversity. So as I said, subsidiarity, but also the role of substitutive powers, the principle of jurisdictional redundancy, and lastly, but also most importantly, federalism can give us many tools to understand the differentiation and the asymmetry of the law of diversity and how to manage it. So federalism, asymmetric federalism is today a reality. It's always been, as someone says, Francesco, Lidia, and it has developed many instruments to manage this differentiation, understand this asymmetry, also fiscally speaking, which could be also something interesting for minorities. So, in conclusion, if you're still curious, there's more actually. So there's already another book that has been published in 2025, specifically on the relationships between federalism and the law of diversity, where I and Martina Trettel asked many renowned authors, within whom also Kyriaki, to develop these relationships, these theoretical links, also on a more practical basis. And then there will be, hopefully, another book on the law and governance of diversity to be published by Routledge in, I think, beginning of 2027. And then we will dive more, also not only in the theoretical dimension, but also more on a normative and empirical basis on the law of diversity. And so that's the end of my presentation. I thank you all for your attention and very much looking forward to the discussion.
Thank you so much, Nicolò. And actually, we also learned that the law of diversity is not only an evolving concept, but it's also an evolving publication process because it actually evolves alongside with the theoretical considerations made in different publications. And without preventing further debates now that the two discussants will probably launch, perhaps when you were speaking about the key elements of the law of diversity, and you were underlining the importance of negotiation and pluralism in general, I was wondering whether it is actually also aging. It's not only the little brother of minority protection, but it's probably also getting older in this new world order where negotiation and pluralism are pretty much at risk. But this is something perhaps for the discussion later on. As you also mentioned, asymmetric federalism, that was the perfect bridge to pass the floor to Lidia Bonifati, who will be the first discussant of your book. So Lidia, thank you so much for joining, and the floor is yours.
Thank you so much, Francesco, and thank you so much, Nicolò, for your presentation. I'm really happy to discuss your book with all the participants. Nicolò and I shared much of our PhD experiences, so we could respectively see our research unfold. So I'm really, it's really emotional for me to be here as a discussant of the monographs of the product of your PhD. I will be rather short and in expressing my comments, and then I'll dive into a couple of questions that I have for you. Of course, it's rather evident what are the innovations of your work. The really impressive theoretical effort that you developed in the book speaks for itself, and I really learned a lot, especially in the chapters on the bottom-up models emerging from the Global South experiences, and the fact that you decided to reject epistemological hierarchies is really an added value to your work, and it allowed you to, of course, explore non-traditional settings and contexts. And I think that it was really a precious perspective to add to the analysis. And of course, the concept of the law of diversity has all its advantages and its risks, as you already explained. But I think that, of course, the idea of imagining a wider, broad conception of minority indigenous rights protection is something that is very much needed in the contemporary world. And of course, taking a global perspective is essential in doing so. And the second theoretical effort that you made was to address federal theory as an explanatory lens for the concept of law of diversity. And Nicolò was able to address and engage with classics, but also emerging strands of the literature, emerging scholars, and non-mainstream perspectives on federal studies. And I really liked also early on in your PhD, the idea of federalism and the law of diversity, not as separate islands, but as an archipelago. And I think that's really effective in showing how you relate federalism and law of diversity. And this is a link to perhaps a first question, because you used federalism and the federal theoretical framework as a way to explain better the concept and the models of the law of diversity. And I was wondering how it could be the other way around in some sense. So what you mentioned, the wisdom of federalism, but what about the wisdom of the law of diversity for federal studies? Because some of the flexibility of the non necessarily top-down solutions that you mentioned, perhaps could, in your opinion, could be used in federal studies and in designing federal solutions, especially in case of conflicts. I'm thinking about cases where ethnic or ethnocultural conflict was addressed using federalism as a conflict resolution tool. And for example, in Iraq, it showed all its limits. And I was wondering whether an infusion of law of diversity mindset could help using federalism wisely, in a sense. Or even the idea of nested federalism that I didn't know before reading your work. I think it's really, really interesting and could be, I was wondering how actually could be used in other contexts aside the indigenous settings that you analyzed. So perhaps, again, the question is about how it is possible to make these emerging models circulate in other contexts, and not necessarily as from the perspective of minority protection, but from the federal perspective. So this is a much broader question that I have. And the second question is related to the Global South perspective. Of course, you mentioned, especially in the introduction and in the chapter 3, I think, dedicated to the Global South perspective, that you decided not to select a prefixed set of cases, which is, of course, valid and justified. But I was wondering how your theoretical framework that emerges from this book, what are the methodological implications in terms of doing new comparative research using your framework? If you think that some changes to the comparative method should be made, or simply, between many brackets, adopting a decolonial comparative approach is enough. Because, of course, it can be difficult relying on Western concepts applied to non-Western contexts. And so I was wondering whether you also reflected about the methodological implications of this new emerging concept of law of diversity. And so, yeah, I think that the main questions are these ones. And of course, we can further discuss about this after Kyriaki's comments. Thank you so much.
Thank you, Lidia. And I would give the floor right away to Kyriaki also, because we are a bit short of time. So Kyriaki, please.
Thank you so much for involving me in this exercise. I have been following, as Nicolò mentioned a number of times, his work for a while now. So in one sense, I think I've been growing into the law of diversity with Nicolò, and I think we will continue this, journey, it seems, also moving forward. So I would like to use my few minutes as a discussant in the following way, to echo the relevance and importance of his work and this book for diversity management and diversity governance, as I prefer to call it, especially given the conceptual and framework and completeness of what we have now in contemporary societies to protect minorities from a legal perspective, but also, and more importantly, as an opportunity to ask a few of the questions that I have been considering when trying to understand and explore the law of diversity from the perspective of a scholar who is a socio-legal scholar. So for me, this work, the previous work, and possibly the book that we are also working on right now, begs four important questions. So I've read what we had to discuss today from the perspective of four questions. My first question is, which approach to law is the one that works best for the law of diversity? So from where I stand, law must be approached also as a cultural phenomenon, including in its soft law components. And the cultural embeddedness of solutions is, as far as I understand, not foreign to comparative public law methodology in any case. Neither is asymmetry, pluralism, negotiations as the element of negotiation, rather, as identifiable features when we're trying to understand and process and assess differences across legal cultures and systems. So if you add to that the speed of social change, that law is failing, and we have to be honest about that, failing to follow, especially when it comes from the role of non-state actors and minority groups, I think it's inevitable that we should reconsider what we should account as law within the law on diversity, especially if we want to respond to the fast and hard progress that states have to undertake in order to accommodate the demand for more efficient diversity governance. So that's my first question. The second question is, why should a law of diversity matter anyhow? I think we more or less gave the answer, because difference is the rule and equality is the exception in our world today. But allow me very briefly a little bit of Greek philosophy here as a Greek. I found an interesting bit that I think speaks very well to our discussion. Apparently, this is not a question which is recent. It's a very old question, the one that I'm trying to answer. Why should a law of diversity matter? In Plato's dialogues, Minos in particular, the Socratic question, what is law for us? And I place the emphasis on the for us part, suggests that obviously the meaning of law differs between communities. And more than that there is a tension, a conceptual tension between understanding law as the discovery of things, and I would add things that work in a given society, and the law as the emanation of an authoritative, political institution within a given community. So on the basis of that tension, the criterion for law, I think, becomes, and that's what you find in Minos, whatever preserves rather than destroys cities. By cities, you can, substitute political communities. And what preserves a political community could and is differing between times and contexts, and can result in different laws that all may differ on what is required to, preserve cohesion within a society. Now, Minos concludes with the observation that what is intrinsically good for individuals may be different from what is good for cities or communities, reaching at the same time another important conclusion, which I think is relevant for our discussion. Law's diversity can never fully render justice to human diversity. And on the basis of that, I think we should, reflect a little bit more on how we approach the shifting paradigm of Roll's law as protecting difference as opposed to providing equality. Now, as was already mentioned, minority studies have been deeply engaged with understanding how national, ethnic, new, old minorities, minoritized groups, as is now the fashion, develop their identities as recognizable subjects in need of legal protection. But again, the quest is not new, and it's aligned with the Socratic understanding of law's universality as the one that is compatible with the greatest diversity of values and beliefs. This is how I read your work, but maybe, and connecting it with other stuff, but maybe that's not what you wanted to say when it came to why should a law of diversity matter. My third question now is, what kind of equality are we talking about within a law of diversity? And I think that's also something important. The main instrument that we have been using so far, especially in minority studies and anti-discrimination and equality studies, to defend cultural pluralist approaches has been to build around this concept of equality. But equality at the same time has been heavily criticized as falling short of delivering an adequate standard of fairness for vulnerable and minority groups and disadvantaged groups. Moving in this direction, and obviously I would suggest in an understanding of multidisciplinarity, the law of diversity has to reflect on the fundamental query of what constitutes the rule and what the exception in each context, and how can we facilitate through that understanding the coexistence of different groups. Now, comparative studies of contemporary European constitutional texts suggest that there is an increase when it comes to the number of grounds of discrimination that are being recognized in them. So if you look at the constitutional text, you would probably, only the text, you will get the sense that, factors of difference are acknowledged. But there is at the same time a distance observed between constitutional text and socio-legal dynamics and processes at play that prevent minority groups from achieving substantive and meaningful equality in opportunities. So going back to the role of the law of diversity, I would say that the ideal task of developing such a law is to reflect within constitutional texts and overarching norms a balance between difference and equality, autonomy and inclusion in the way that you have referred to it. And then, of course, as you said, proportionality, efficiency, sustainability assessments are part and parcel of this consideration. If we accept that the law of diversity is a law that has to be more inclusive in its construction and outlook. One example that I have been confronted with, and I would really like to hear your thoughts on how that is and could be embedded in the law of diversity, is the challenge to embed intersectionally factors of vulnerability that apply to traditional and new minority groups within the law on diversity, and how would that reflect, in your vision of the law of diversity. And as time is of essence, I will immediately move to my final question, and I think that's the one that is perhaps least discussed so far. How should we approach a law of diversity? And here I'm taking a governance approach. The law of diversity, and I'm quoting Francesco's definition, has been defined as the body of law that has been and is being developed to deal with the issues involved in accommodating the differences represented by diverse groups within a pluralistic society. So the way I read this definition, it represents a response to the need to consider the broader matrices of disadvantage, whether we speak of gender, whether we speak of political opinions, convictions, socioeconomic status, just to give you a sense. But for me, if we want to be serious about, a governance reading and applicability of the law of diversity, which we should study it from 4 axes: governance, actors, values, and tools. I'll go through them very briefly in the way that I see them at play and what I could read between the lines from your work. When it comes to values, I think a law on diversity has to be explicit about the reasons and normative goals for diversity governance, which, by the way, will be circumstantial and will vary. Values are necessary to reflect a shared basic judgment of what is right or wrong, what is valuable and not valuable in any given context. And usually, from a minority perspective, they involve considerations of peace, very important today, sovereignty, transparency, human rights, and so on. Tools. A law of diversity, the tools for the law of diversity. Here, you made the case for new methodological and analytical tools. Legal pluralism you mentioned, federalism you definitely mentioned, but then we can also add, intersectionality and others that are likely to capture the multiple and complex ways in which our societies are developing and diversifying. But of course, then I would say what's the next step, and what I see as a challenge is how to devise adequate legal indicators that allow a fair and equitable outcome in terms of diversity governance. Actors. I think that the law of diversity, the way I read it, is a collective effort of multiple stakeholders. You talk about this, but not in a frontal way, indirectly. The state obviously is no longer the sole locus of authority over territories and populations. It is a regulator, but in some cases, it's also the object of regulation by, let's say, other states, international organizations, even private actors. So we're looking at a more dialogical relationship here. And the law of diversity also would probably rely more than we think on polycentric solutions and multi-stakeholder approaches, which, by the way, would have a higher chance of generating public trust. When you devise a locally appropriate solution, then it is possible that trust will increase as a result, provided, of course, that the actors exercising power have the right to rule and exercise the right appropriately, which is, within the stricter realm of constitutional law. Last, but definitely not least, the governance perspective of the governance dimension of the law of diversity. And here I think things get very interesting. If we adopt a polycentric diffusion in the way that public tasks and diversity governance is organized, then we're looking at options that are devolved, decentralized, and which actually, as a matter of fact, have proliferated in managing diversity at state level. But as the types of diversities, in inverted commas, have grown in exponential growth, and as grounds of protection of difference proliferate, I think the regulatory framing of difference and the way that this is embedded in law and policy making must be more horizontal. Which brings me to one important, element here. If we're looking at the polycentric diffusion way of organizing things, then we need to also consider hybridizing sovereignty and adopting polycentric forms of governance. And here, governance occurs through interconnections among sites, multiple sites, with overlapping spheres of jurisdiction. And the law of diversity, I think, allows that because polycentricity is embedded in its if you want, essence, contributing also, among others, to resilience to shocks, very important today. We want resilient societies. The efficient provision of public goods, the increase of trust that I already mentioned, distribution of leadership among competent actors, and the creation of new institutions and new forms of public entrepreneurship. So we are combining, by hybridizing sovereignty and becoming and adopting a more polycentric form of governance, diversity, disaggregation, and diffusion, against concepts of more classical concepts of position, grouping, and order, which are more characteristic of centric systems. But of course, I would be naive if I did not acknowledge the risks that come with such polycentric forms of governance embedded within the law of diversity. And these you did mention. So all in all, from these four different standpoints, and I'll finish with that, I was wondering how we could, conceptualize the functionality, the application on the ground of the law of diversity, if we are to move forward, in making this a very state-of-the-art-ish, relevant, and I would say also valuable successor to minority protection. And I'll stop here and thank you so much.
Thank you, Kyriaki. I think as we have some 15 minutes to go, max, we can probably collect further questions as to challenge Nicolò even further. I mean, the questions raised already are not easy to answer. But that's a trick, Nicolò. So at the end, he will say, I will have so much to say, but unfortunately, we are short of time, so I cannot provide you with my wisdom. And we can perhaps collect more. I look into the audience. Camilla, please.
So, good afternoon and say good evening, everybody. Thank you very much for the presentation. I really enjoyed it. I just have two very short questions. The first one is a methodological one. So you have said that basically this was your PhD thesis and you developed it into your book. And I am currently doing the same. So I'm in the same torture processing. And my question is, what was the main difficulty that you have encountered when you developed your thesis into a book? And the second question, more of, let's say, more regarding the content. And you said that this is not part of this book, but you have also further developed this strain of research on the situation of new minority groups. So what is the potential of this law of diversity to accommodate the needs of new minority groups? And what is the impact of the instruments addressing the needs of these groups on historical minority groups? So what are the synergies and the tensions between, let's say, new and historic minority groups and the ways in which we treat them? Thank you. That's it.
Excellent. Giuseppe.
Yeah, thank you very much for this presentation and for the terrific comments offered by our discussants. I also enjoyed the volume very much, especially the part in which you try to go beyond the usual suspects, also trying to cover some examples from the global south. I think this is very welcome because sometimes we are really obsessed with the idea that federalism is can be reduced to some experiences that actually it is a very plural phenomenon. So I have two questions for you. You argue that the law of diversity serves as a sort of gate opener to overcome the constraints of traditional and minority rights law by shifting the focus from who should be protected to what is required to manage the diversity effectively. But I'm interested in the dark side of this. So when we move away from this top-down approach, what are the primary institutional risks, such as the fragmentation, for instance, or paralysis? And how does your framework address these risks? After all, constitutions can be seen as a risk management devices. So I think this is connected to the core of your proposal. Second question, in contemporary scholarship, there is a recurring debate raised more recently, sharply by authors like James Gardner, in his latest piece for Publius, about whether subnational autonomy can actually survive as central government slides toward authoritarianism. Now, given your analysis of emergent models like legal pluralism and participatory democracy, do you believe that a robust, deeply embedded law of diversity can serve as an effective institutional shield against autocratic centralization, or is it inherently vulnerable, to being crushed by a majoritarian center? Thank you very much.
Great. Are there further questions? Am I allowed to ask one? as well?
You are, of course.
Okay. Well, in short, is there a maximum of diversity that law can digest at some point? The question comes from, the idea of constitutionalism being grounded in a society that should show some degree of homogeneity, but no one can define that in a way. I wonder whether, of course, it is not measurable, but do you imagine that at some point there must be a turning point when the diversity is too much and society doesn't work, or is it an open-ended process? So, Nicolò, it's a challenge. You have some 10, 12 minutes max to respond to all these questions. The floor is yours.
Thank you very much for all your comments and questions. I'm very impressed and very afraid of not being ready to answer all, but I will try. So starting from Lydia's questions, I find it, and comments, I find it very interesting that she talks about the wisdom of the law of diversity for federalism. So the idea that this less institutionalization, flexibility, how can this apply to federal organization? I think that this relationship, the law of diversity and federalism, is not univocal. It could be also at both sides. So both sides can affect each other. So in a way, in the direction of both relativizing these institutional assumptions, and also I would say there's this elephant in the room that we don't mention, that these are the nation-state categories that are still behind all the constitutional categories, the constitutional tradition and constitutional thought. So maybe together they can better move towards relativizing more this idea of the nation-state and this shadow of the nation-state behind constitutional categories and federal organization. So in a way, if we bring my considerations to the extreme, we could also, in a way, try and propose a renovation of federalism as a setup, because I didn't want that. I didn't want to explain what federalism is. Sorry for this very weird light. I tried to move here. Because I wanted to use federalism in an analytical way, but putting that to the extreme, this could also be useful for federalism as well, actually, to also dare question a little bit this nation-state bias, these nation-state categories that still condition discourses and studies and applications of federalism. So maybe I don't know how precisely, but at the same time, these many forms of decentralization, if only they were already considered as forms of federal arrangements, this could in a way already bring the discussion way forward of than it is now. So a very interesting point, and it's something that we should work on. Global South perspective, the methodological implications. I think that you will see many of them in the next book, because I forgot to tell that Kyriaki is editing this book with me and Joshua Castellino. And this new book is very much focusing on exploring the methodological implications of the law of diversity. So what we try there is really to go and explore really many further areas, not only of the world, because we are focusing on many countries that have really not been focused on, and new fields, new areas related to diversity accommodation that are generally not related to this. in this way, the Global South perspective is one of the dimensions of this enlargement of this perspective. So we don't want to look at the usual suspects in the Global South, but we want to look at new models, new in a way, because they have not been that much studied. And another implication is really to consider the models coming from the Global South as something that can also circulate, actually, in another direction. There's someone also, I remember Toniatti, that talks about that, about the models of the South American region that can circulate back in a way. So why not considering Global South as it deserves the same way we consider Global North. So the idea that also these models can circulate, because we assume that they cannot generally. So naturally, we will need to adapt and to contextualize. So it's a big exercise of contextualization that we will need, and that is also related to the use of the concept of diversity, because I don't want the demise of minority rights, as I said, but at the same time, as you said, Lidia, is a Western concept, and that does not apply to many regions of the world. That's why diversity could be also a gate opener in this way. So using diversity to understand accumulation of diversity in places where minority rights are not employed concepts. So moving on to Kyriaki's dissertation, because I mean, it was amazing. You should write a book about that, because this connection also with Greek philosophy, I really loved it, and I find it very, very interesting, and something that brings us very much forward and beyond what I did so far, but at the same time something that we really need to focus on. And I think that in our book, in our next book, we are focusing on some of these questions. I would say these are methodological and normative issues. So methodologically, I totally agree that we cannot do without a social legal approach to the law of diversity. What I try to say in the book is that we see this difference between, and this distance between law in the books and law in action, and also this distance between legal categories backed by these nation-state categories and social change and social dynamics. So social dynamics are quick, they evolve quickly, they need significance and relevance, legally speaking, to be addressed and protected. So we need a law that is quick enough to evolve along with social change. And that's something from a methodological and normative perspective that the law of diversity should aim for, I would say. So normative perspectives were not the focus of this book, but it's something that I'm trying also to work on in the next phases of my publications. But that's something that I would argue for. And also that's something that Francesco and Jens argued for, this idea of a law that goes along with social change, as a law that is more flexible because more adaptable, and adapts as society adapts. And so this rigidity of legal categories, of nation-state categories, should be in a way adapted to this contemporary complex world. And so, yeah, that's why the law of diversity matters, because if the law of diversity may now have some limitations, that does not mean that it doesn't have usefulness. It is not useful. It is useful, and I would say that is much more useful and necessary today to still focus on this area and to still focus on interesting and innovative and useful models to accommodate diversity in counter tendency to current events. So we need also we make a statement when we work on that. not. We make a statement that we focus on diversity, we want to foster diversity, and we want the law of diversity to matter specifically in these times where when these nation state categories are back to the front. And mainly used as a weapon against diversity. What kind of diversity?
Sorry to put pressure, Nicolò, but you have 5 minutes max.
Yep.
So you can also skip some, like my
yeah,
question,
no, I
for
think
example.
I can make it. Yeah, thanks. What kind of diversity and equality we should focus on, which is the rule, which is the exception. That's a warning from Kyriaki, and I get it. We should still focus on the practice and then focus on the application, the implementation of the law of diversity, and see what happens there on the ground. And that's something that maybe my book was not doing that much, because it was kind of focusing more on the theoretical part, which was supposed to open these kind of discussions, actually. And then so we need to keep in mind that diversity means also, in a way, to find equality naturally. And I totally agree with the idea that in this perspective of making the law of diversity more flexible, intersectionality must have a huge place. And that's something on which a specific chapter also of this book will focus on, intersectionality and the law of diversity, how the law of diversity can actually, in a way, help integrate non-discrimination frameworks, promoting intersectionality in a way, because it goes in the same direction, we would say. In this direction that is against the essentialization of minority categories. And then how should we approach the law of diversity? I would say that's a manifesto for the law of diversity. We should just print it in our office and keep it behind us. I cannot but agree with all these dimensions of the law of diversity. And you also mentioned polycentricity also in your chapter in the other book, Federalism and the Law of Diversity. That's a model that should be more explored. What I try to do is always to find a link with constitutional theory and constitutional thought. And the link there is subsidiarity, I would say. Horizontal subsidiarity is something that can be used theoretically and practically to foster this model, actually, to encourage this model that you very well described, based on governance, actors, values, and tools. So devolution, decentralization, but in a way that is not the ancient way, the traditional way, and following principles of polycentricity, which is something that we should dive into. Then I will move on to Camilla's questions quickly. The method from the PhD to the book, it was, but I was kind of lucky, actually. It went quite swiftly, but it was tricky to make it interesting to sell, actually. So to create your book proposal, to make it short, to make it interesting immediately, because you are actually evaluated based more on the proposal than the book, the entire book itself, naturally. So it's something that is different from research. You are trying to sell your product, and that it's something that can be tricky sometimes if you have imposter syndrome like me. And then potential of the law of diversity, that's something that I'm working on. The idea was not to put normative perspectives in the book, but the idea is really that the innovative models, naturally not only because we can also discuss the extensions of minority rights, but also the innovative models could be interesting to apply to migrant minorities, for instance, especially because there's no political will to extend minority rights, and then minority rights costs, and then they need infrastructure, and then sometimes they also in a way they may not be the best solution. So that's something I just need to pass quickly like this, but we can also discuss that in another moment. The law of diversity and its dark sides. Very good question, Giuseppe. There are many, especially on legal pluralism, for instance. That's something we discussed with Kyriaki also. And also this idea that, yeah, flexibility and less institutionalization at the same time, that's something that can be instrumentalized at the same time. Why we need minority rights if there's this? No, so that could encourage the demise of minority rights in a way, because we could use these more these easier instruments. So we really need to focus on these dark sides and argue and demonstrate which use can be done of the law of diversity, and how we can avoid them. Also. Naturally, this and explain specifically that these innovative models are not the solution for all situations. Subnational autonomy and authoritarianism. It's something that I'm studying in the framework on another project. The law of diversity may serve as a shield, but it is also vulnerable. So I mean, that could not be. I would say that the law of diversity depends on many other shields that should work together against authoritarianism, but normatively putting forward the law of diversity is already, as I said before, a statement that should favor moves against authoritarianism. And at the same time, subnational autonomy can be a laboratory on the other side. So we see laboratory of illiberalism, but also laboratory of diversity accommodation that could be very interesting, maybe more at the local level than the subnational level, which is something that maybe we still overlook. The last question from
the
Francesco.
last question, I'm afraid we don't have the time for it, but
yeah.
That gives me the opportunity to book Giuseppe for the next presentation of your upcoming book, also together with Kyriaki. So keep it for then.
Okay.
We have to close.
Deal.
Giacomo, do you agree?
Perfect.
Okay. Very good. Thank you very, very much, everyone. It was nothing less than what was expected, and we'll keep going. Thank you all. See you by the at the presentation of the next one.
Thank you very much.